Carlos Seino was sentenced to life in prison without parole on Thursday after a Norfolk County grand jury convicted him in the 2002 the murder of Daniel DaCosta, a custodian at Quincy City Hall. DaCosta, 43, was found dead by a dog walker on August 3rd behind the Thomas Crane Public Library in Quincy. DaCosta had been last seen leaving Sully's bar in Quincy Center at 1 a.m. The walkway behind the library was a shortcut to his home on Francis Avenue. Seino, 49, of Randolph, was interviewed by police shortly after the murder and placed himself in the bar that night but, as a state police officer testified, denied having touched or interacted with DaCosta. Following a felony conviction in Plymouth County, Seino's DNA was taken and entered into the state DNA databank. In May of 2006, that DNA profile was matched to DNA evidence taken from the person of Mr. DaCosta. Although DaCosta's wallet was still in his pants, a large roll of bills he had when leaving the Chestnut Street bar where he had cashed 2 checks at the bar was missing. This has been a long ordeal for the DaCosta family. This remained an unsolved crime for nearly 4 years. Thanks to advances in DNA analysis and the work of the State Police Crime Lab, we were able to serve justice and hopefully help Mr. DaCosta's family move forward from this tragedy, Norfolk District Attorney William R. Keating said in a press release. At the end of a week-long trial in Norfolk Superior Court that featured about 40 witnesses, Assistant District Attorney Thomas Finnegan told jurors in his closing statement Wednesday that the most critical finding of the trial was that Seino's DNA matched blood stains found on DaCosta's clothes. The probability of police finding a match for those stains, Finnegan said, was 1 in a quintillion. That's a 1 followed by 18 zeros, he said. He left behind something better than a footprint, better than a tire track. He left 2 drops of blood. DaCosta cashed 2 checks worth $603 at Sully's, his regular drinking spot, on the night of August 2nd. Finnegan said Seino, who was also in the bar that night, needed money, saw DaCosta's wad of cash, followed him home, and hit him with a blunt object behind the library and stole the money. DaCosta was found the next morning about 7 a.m. by a walker. His wallet was not missing, Finnegan said, suggesting his killer knew what he was looking for. At some point, Carlos Seino came in and he needed money, Finnegan said. He saw Daniel DaCosta at the end of the bar with a wad of cash. And he thought, this guy is drinking, and he has money. But defense attorney Beverly Cannoni took aim at the prosecution's case, describing the trial as Kafkaesque. She told jurors that the bloodstains do not provide enough evidence for a conviction. Imagine what it's like to be Carlos Seino, she said. You're sitting here for 2 years, waiting for your day in court, terrified the jury won't believe you because of this spot of blood. Seino was not named as a match until 2006, after his DNA was entered into a statewide database as a result of an unrelated 2004 conviction. DaCosta's death had been a cold case until state police ran a routine cross-check and discovered the match. Cannoni said Seino's DNA could have rubbed off onto DaCosta's clothing at the bar, suggesting it came from a cut on Seino's hand that night or from sweat.
Court upholds conviction in 2002 Quincy murder. Updated May 8, 2018, Boston. The state's highest court has upheld the murder conviction of a former construction worker accused of beating a Quincy City Hall janitor to death behind the public library more than a decade ago.
Carlos Seino, do hereby make oath that the following statements are true. I am the defendant. I'm currently 58 years old. I'm currently and unjustly serving a life sentence without the possibility of parole at the North Central Correctional Institute in Gardner, Massachusetts. On June 19th, 2008, a jury found me guilty of first-degree murder on the theory of felony murder, where the jury also had found me guilty of armed robbery. I had been represented at my trial by court-appointed and then CPCS attorney in charge, defense counsel Beverly Cannoni. I am innocent of all the charges against me, and my conviction people were no longer able to be located to support my defense at trial. Attorney Cannoni had hired a private investigator named John, last name unknown, to look into the witnesses in my case. When I found out through my attorney that John was a former Quincy police officer, I told Attorney Cannoni that I wanted to meet the investigating officer working on my case because I felt that using a former Quincy police officer to investigate a case which was being brought against me by the Quincy police was a conflict of interest. I communicated my concern. The pants pockets of Mr. DaCosta, Attorney Canoni never pursued the issue and never allowed my DNA expert to testify about it at trial. Despite having also retained a blood spatter expert, nobody was called, no blood spatter expert there. And he's saying, you know, he was at the bar that night. He had worked that morning and cut his hand and got sent home. And there were witnesses that saw it, I think that he worked with or something. But yeah, he was sent home and he had a hand that was bleeding and was at the bar and around, you know, Quincy that evening. The Commonwealth filed a motion to exclude references to CODIS. Canoni never bothered to oppose the Commonwealth's motion, despite knowing that Gwen Pino and Robert Pino were fired for lying, fabricating, and mishandling the evidence at the state lab. Despite knowing that the police were lying, fabricating, covering up, and withholding evidence in my case, Attorney Canoni agreed with the Commonwealth and allowed the trial judge to instruct the jury that the defense agreed that the police were diligent in their investigation into Mr. DaCosta's death. It was actually Attorney Canoni's idea. The Commonwealth wasn't even going to bring up the fact that he had been charged with another crime, and that's why they had his DNA. It's a mess. We'll get there. In fact, I got completely railroaded. No witnesses, no expert witness to fight the overwhelming power of the Commonwealth, deprived completely of all constitutional rights I was supposed to have under the law. In 2009, I was appointed to the Quincy District Court. In 2014, I was appointed to Superior Court. That is the position that I currently hold. Over the course of my career at CPCS, I tried between 50 to 75 Superior Court jury trials, including several murder cases. I tried many cases that had complicated forensic issues, and I frequently appeared on education panels at CPCS and MCLE that focused on forensic science. On May 22, 2006, I was appointed to represent Carlos Seino in the Quincy District Court. I represented him from that date through trial in Superior Court. During the course of my representation of Mr. Seino, I obtained funds and hired expert witnesses in DNA, John Abbott and then Carl Latt, pathology, Jennifer Lippman, MD, and blood spatter, Stuart James. Where were they at the trial? Each expert assisted me in evaluating the Commonwealth's evidence and informing my cross-examination of Commonwealth's expert witnesses. I did not call any of the expert witnesses to testify on Mr. Seino's behalf at trial. Mr. Seino was arrested approximately 4 years after the death of the victim. I do not recall, nor does my file reflect, that he provided me names of potential witnesses when we met at arraignment in the district court. A CPCS staff investigator, John Moore, investigated Mr. Seino's case by speaking with several potential witnesses, visiting the crime scene, and drawing diagrams. John Moore was never employed by any police department in any capacity. I do not recall, nor does my file reflect, that Mr. Seino ever raised a complaint about Mr. Moore or the quality of the investigation effort. I do not recall whether Mr. Seino ever raised concern that the photographs of the area surrounding the library taken by police were inaccurate. I do not recall, nor does my file reflect, that Mr. Seino ever objected to the jury going on a view of Sully's Bar or the Thomas Crane Library. I decided that it would be better to stipulate that law enforcement acted diligently over the 4-year time period between the death of Mr. DaCosta and the arrest of the defendant than to have the jury hear the details of the CODIS hit and learn that Mr. Seino had been convicted of a crime. I have never had any information that the Quincy police altered evidence of the victim's death. I have never had any information that Quincy police moved the victim's body or changed his clothes. I am not aware that Mr. Seino is the subject of illegal surveillance while awaiting trial. I do not recall, nor does my file reflect that I ever requested discovery regarding renovations to the library, nor do I recall there had been renovations to the library from the time of Mr. DeCosta's death to the date of trial. Signed, Beverly J. Canoni, January 11th, 2018. Okay, I think I have all the hearings in order, but it was really hard to try to organize all this. There was a lot of stuff that was out of order. All right, so in the Superior Court, October 5th, 2006, Dedham, Mass. Thomas Finnegan, ADA for the Commonwealth. Beverly Canoni, Esquire, Committee for Public Counsel Services for the defendant. The court. Could I have Mr. Seino brought in, please? Defendant enters courtroom. Your Honor, for purposes of the record, this is docket number blah, 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 the Commonwealth versus Carlos Seino. Could I have counsel identify themselves for the record? Ms. Canoni. Thank you, Your Honor. Beverly Canoni for Mr. Seino. Your Honor, I was appointed to represent this gentleman in the Quincy District Court. Yes. He is still indigent. I would ask for an appointment here as well, please. Yes. Mr. Finnegan. Tom Finnegan for the Commonwealth, Your Honor. Yes. May I proceed, Your Honor? Yes. The clerk. Mr. Seino, docket number 059901, sorry, on the third Tuesday of September 2006. The jurors for the Commonwealth of Massachusetts on their oath present that Carlos Seino of Randolph in the county of Norfolk on or about August 3rd of 2002 at Quincy in the county of Norfolk did assault and beat Daniel DeCosta with intent to murder him. And by such assault and beating did kill and murder said Daniel DeCosta in violation of the Massachusetts General Law, Chapter 265, Section 1, against the peace of said Commonwealth, and contrary to the form of the statute in such case made and provided. It is a true bill signed by the foreman of the grand jury and the assistant district attorney for Norfolk District. Sir, to this indictment of murder, how do you wish to plead, guilty or not guilty? The defendant, not guilty. The court. And do you wish to waive your right to a formal reading of the other indictment? The defendant, yes. The clerk, thank you. What say you to 002, armed robbery? Are you guilty or not guilty? Defendant, not guilty. The clerk, thank you. Question of bail. Mr. Finnegan, Your Honor, the defendant is currently held without bail since the time of his arraignment in Quincy District Court. I would ask that he be held without bail on these charges. I've turned over a lot of discovery today. The court. Yes. Mr. Finnegan. If Ms. Canoni wants to make a bail argument today or reserve the right to argue bail at a later time, Ms. Canoni. If we could argue it at a later point, Your Honor, I have no objection to him being held without bail, without prejudice at this point. All right, held without bail. Mr. Finnegan. Thank you, Your Honor. The clerk. It's a C-track case, counsel. Ms. Canoni. If we could pick at least initially just a pretrial conference date in December 13th, please, for a pretrial conference. The court. All right, December 13th. Ms. Canoni. Thank you. The clerk. Mr. Seino, you're going to be held without bail. That is set without prejudice. That will be argued at a further point if necessary. Your next court date is 12/13/2006 for a pretrial conference. That's 12/13, sir. Thank you. Mr. Finnegan, thank you, Your Honor. Ms. Canoni, thank you, Your Honor. It was March 8th, 2007. Court called to order. Defendant not present. Ms. Canoni. Seino, the clerk. The Seino matter. That's number 8 on the list. Good morning, Your Honor. Beverly Canoni for Mr. Seino. The court. Does your client need to be brought out? Ms. Cannoni. He does not need to be brought in. I've spoken with him. The court. Okay, and you're here for a pre-trial conference. Did you file a pre-trial conference report? Mr. Finnegan. We are, Your Honor. We've conferenced it further this morning. Okay. We're working on some discovery matters. Okay. I think the Commonwealth is in agreement. What it needs to provide is some photographs and some DNA. Okay. Documentation. I'm trying to assemble that in anticipation of April 26th, which is our next date for discovery motions. For discovery motions on April 26th, okay, do you have a pre-trial hearing date? I think it's actually the same date, Mr. Finnegan. Yeah, we put them both on for that date, the 26th, Your Honor. Court, fine. Which appears on the record. Then you're all set until April 26th? I think we are for today. Yeah. Okay, thank you very much, the clerk. April 26th for discovery motions. Thank you. Thank you, Your Honor. Thank you, Mr. Clerk. Whereupon the matter was adjourned until April 26th, 2007. April 26th, 2007. Court called to order. Defendant present. Ms. Cannoni. Your Honor, this is a case that involves some DNA testing. When we were last in court, I told Mr. Finnegan that I would get from my expert a list of exactly what he needed from the chemist's DNA file. My expert passed away in the interim. I do not have that list. I do have, hopefully, someone who will step into his place, someone who is local. That has been the problem. The DNA experts my agency has been using are scattered all over the country. The person I am trying to make contact with is in Connecticut. So I'm hoping that I can get him on board quickly and give him the discovery that has been provided to me. I think the discovery is probably about this thick at this point. I have had a copy made to send out to him and get moving with that aspect of this. The court. Okay, so what can we do at this point to move things along? Mr. Finnegan. Your Honor, I would like to file a notice of discovery creating some additional discovery. I also have, Your Honor, a motion to allow the Commonwealth to perform some additional DNA testing, which might be exhausted. There are 3 additional items of evidence that were collected at the scene: a shirt, a drop of blood, and fingernail clippings from the victim. What? Part of that motion, Your Honor, provides the defense expert could be present, and obviously it can't be done at the moment because I'm not sure how best to proceed on the motion. It could be allowed subject to the engaging of the new expert, or we can hold it for the moment until a new expert is engaged. Ms. Cannoni. I am told that this expert, one of the reasons I want to hire this person is that he is available to go to the Massachusetts lab and be there for the testing. So I would think that this is something that we could work out, hopefully very quickly. I do have a motion for funds allowed for him. The court. So once you get that expert on board, you expect you're going to be able to come to an agreement on this motion? Yes, I would like my expert present for this. I have no problem with the exhaustive testing. What's being done with him present? Okay. I think he can coordinate. I'm told that he has a history of working with this lab. The court. Do you have a sense of how soon you are going to have a commitment from him? I would like to have a commitment by next week from him. I think that's realistic. Okay, once that happens, you work out the details of this exhaustive testing. What comes next? Ideally, I would love to try this case in the fall. I would like to try this case as soon as possible. With my schedule, the fall seems realistic. I haven't spoken to Mr. Finnegan about that, but it seems with everything that's in this case, that's a realistic date. Is it a case that is definitely going to trial? Yes. Why don't we go ahead and appoint a date right now before the fall dates get otherwise occupied? In the meantime, we can address whatever we need to. How long do you think this case will take? Ms. Cannoni, a week maybe, Judge? Week and a half? Does the court want to put it on the first day of this session? We're looking at October. You're looking at October? If we could. So October 1st? If we could. The court. I think we can do that. All right, October 1st, a final pretrial conference. If we could do it maybe 3 weeks before? Okay, say September 13th or thereabout. That's fine. Mr. Finnegan, the 13th? The court, I think that's fine. September 13th on a pre-trial conference. Miss Canoni, if we need to come in anytime during the course of the summer, may we just arrange it with the clerk? That's fine. Should we set one more stated date just to confirm that you've got your expert lined up and you have resolved issues about testing? Yes, within a month or so? Yes, so pick a date in May. May 23rd, Your Honor? May 23rd is fine if you're not expecting something substantial and contested. I'm trying to block out a part of that date to be somewhere else. Miss Canoni, if there is, we would report that day and there is something that day that there is something contested and substantial. The court, fine. All right, May 23rd then. The clerk. Carlos Seino's Yamadas continued to May 23rd. That will be a status date. Trial on the matter is set October 1st with a final pre-trial conference on September 13th at 2 p.m. The clerk. Good morning, Your Honor. This is Norfolk Superior Court Criminal Action 06-599-001 Commonwealth versus Carlos Seino. Miss Canoni. Seino. The clerk. Seino. Well, I don't know. I guess that's how you pronounce it. And would counsel please identify themselves for the record? Miss Canoni. Beverly Canoni for Mr. Seino. Good morning, Your Honor. Tom Finnegan for the Commonwealth. Okay, good morning. I'm Judge Paul Chernoff. I don't think I've had any contact with this case. Tell me if I have, though. Miss Canoni. No, and this has been from day one a trial, so the court. Okay, so I don't think we ever lobbied this case or had anything with anyone, but certainly not Your Honor. The court. Okay. I do have a motion for voir dire of prudential witnesses. And I will go through these and what I normally do, and I'll try to do this today, is take this and any ideas that are developed by you people here today, put them in a list of questions that I would tentatively plan on giving and give you people a chance to work on that list. And so we will be able to do it. Do you expect we will be able to impanel on Monday morning? Miss Canoni, yes. The court, okay. Miss Canoni, and I'm requesting individual voir dire under the case law, so it may take a little longer. But I think unlike sexual assault cases that a lot of people tend to answer affirmatively and be excused, I don't think we'll run into that situation here. So it may be that we finish impanelment on Monday. Court. All right. How long do you think this case will take to try? Commonwealth. Mr. Finnegan. Your Honor, I do have a witness list here. There are 42 names on it. I think that's a little bit, as I said, I think a few of those names would come off as being repetitive and duplicative, but I think it probably knocks it down in the high 30s. So based on that, my thinking was 7 or 8 days of witness testimony. The court. Does the defense plan any expert witnesses in the case? Ms. Canoni. As of right now, I don't expect to call any expert witnesses, Judge. This is a case that, through no fault of the Commonwealth, we're getting last-minute discovery. And I just sent to my DNA expert the electronic data that I received last Friday, or I actually got it Saturday. So at this point, I don't expect any expert witnesses. I'm not sure whether the defendant will be testifying, and I'm not sure any civilians will be called based on the Commonwealth's evidence. But I think 7 or 8 trial days is the outside. It may be quicker than that. The court. I have a couple of complications in my schedule that would be very difficult to work around. There is one day, and the trial might well not be over with by then, but I am obligated to teach in a program quite a distance from here one day, and I think it's on the 21st. Wait a minute, please stay seated. Let me just get my calendar. It's on a Wednesday. I think it's a week from next Wednesday. The date of unavailability for me is the 18th. Miss Canoni, I think we'll be done, or maybe arguments and charge that day. Well, then it wouldn't be that day. I don't think either of us would mind an extra day. I have other matters which I will move. I have a couple of statuses on some cases which I can try to move to 8:30 in the morning or so. But I think I can give you mornings and afternoons the whole week of the 9th and the entire week of the 16th, except that I cannot be here on the 18th. So 2 full weeks, you'd probably complete this case. But if that doesn't work, I am actually here the end of the month. But I do have some other things. The week of the 23rd, I've got some afternoon obligations, so we can work through that, Miss Canoni. And I think the Commonwealth is planning on their DNA people coming in as early as the 16th. Mr. Finnegan, that's right. The court. All right, anything you anticipate that I, aside from these voir dire questions, I should be confronting on Monday morning? Ms. Canoni, a couple of issues. One, we were talking about it yesterday. This is a case, Judge, where the death occurs in August of 2002. The defendant is interviewed with a whole group of other people within 24 hours or so, makes a statement to the police at that time. There are items sent out in due course through the State Police Criminalistics Bureau for DNA testing. The court. Was the defendant in custody at this point? Ms. Canoni. Nope. He was not considered a suspect necessarily. There were a whole group of people who were interviewed by the police at the time. There is a CODIS hit. Tom, the date of this CODIS hit, I want to say in 2004. Mr. Finnegan, CODIS hit March 29th, 2006. Ms. Canoni, okay, I'm sorry. The CODIS hit comes back in 2006. Mr. Finnegan and I have talked yesterday, and we'll talk a little bit more today. I'm objecting, or we're trying to work out a way that we don't have this initial CODIS hit. Any testimony regarding the CODIS hit. I'm not challenging the CODIS hit. I'm not saying that there was a problem with it, and I have no problem with picking it up after that. In this case, the grand jury requested a sample of Mr. Seinos's DNA. What? He provided that willingly. And what's interesting about this case, several other people also provided DNA. So the Commonwealth's testimony could be that there was this group of people who provided DNA, and then the DNA match came back to Mr. Seino without any mention to the court. And your concern is the possible prejudice of the jury knowing that the defendant's DNA was on file someplace? Ms. Canoni, absolutely. And I think the DNA on file is even stronger than the mugshots that we've been worried about for years. I think mugshots are mugshots, no matter what you say about FID registration and things like that. And I think DNA database is even more explosive that way. And certainly, I'm not challenging the CODIS hit. It certainly doesn't, okay, well, why don't you see if you can work it out? If not, I'll work it out. Mr. Finnegan, I would object, Your Honor. Thinking a little bit more about it, we did just talk about this yesterday, but a couple of things, Your Honor, if I may. First of all, because I'll forget if I don't do it now. But a notice of discovery, I'd just like to file. These are some documents that I've turned over the last couple of weeks, but we haven't been in court. So this is notice of discovery 13 and 14, which I would just like to file. Attorney Canoni already has those. I did do a draft of a joint pretrial memorandum, which Ms. Canoni just saw this morning. So I haven't signed it yet, Your Honor, but I will file that together with my witness list. Ms. Canoni, and I think we'll beef up the statement a little bit, or ask Your Honor to beef up the statement a little bit. What? Mr. Finnegan. But turning to the DNA issue, Your Honor, I did do, and I just gave Attorney Canoni a copy of what I think is the timeline of this particular case. It is almost a 6-year-old case now, Your Honor. It will be 6 years old come August. And the body is found on August 3rd of 2003 of Daniel DaCosta. That's the name of the victim. There's a snippet taken, sent to Cellmark in 2003. An unknown profile is produced in March of 2003. It's uploaded in 2004. And because the defendant's DNA is not in the system, there is no hit until 2 years later on March 29, 2006. So that's almost 4 years after the date of the body being discovered. I think that to not allow the Commonwealth to get into the CODIS, and I'm happy to do it in a very innocuous manner, leaves the Commonwealth sort of open to criticism or wondering on behalf of the jury, like, geez, what was the Commonwealth doing all this time? Why didn't they, if they had access to the defendant's DNA, why didn't they compare it earlier? And the fact of the matter is the Commonwealth did not. There have been a number of cases tried recently, Your Honor. There certainly will be more. Martin Guy, Shea Sosa, Martin Lovato, all tried right here in this court where the CODIS issue and the issue of a match has come up. I think it can be done, as I said, very sort of plain vanilla. I have with me Judge Dorch Okara's instructions to the jury on that issue in Commonwealth versus Lovato, Ms. Canoni, which is my case. Ooh, that's what I need to look up. Which was your case. And this is different than Lovato. And I'd like to explain that in a minute, the court. But for your the probative value of doing it is just to demonstrate to the jury that the Commonwealth was not inactive during this period of time, Mr. Finnegan. That's correct, Your Honor. And I think that it's only fair to the Commonwealth. First of all, I did print off a description of the CODIS, the definition of CODIS. And I think something as simple as that, very plain vanilla description of what it stands for. It doesn't stand, as the court knows, for convicted, It's a combined DNA database. I think that could be explained to the jury, whether through an instruction similar to Judge Dorch Okara at the time the evidence comes in, or both, whatever the defense prefers, Your Honor. But I think there are always going to be cases, Your Honor, for instance, the court. But if all this came out before the jury, even if it was done in the most tactful manner possible, would the jury then be learning that his DNA was not in the CODIS system for a particular period of time, and then it got put into the CODIS system? Mr. Finnegan, correct. But I think, Your Honor, that there will always be cases where, and even if every juror, and I don't think jurors are that sophisticated on the CODIS system, but even if they are, Your Honor, there are always going to be cases where, for instance, and we prosecute them all the time, an assault and battery, or a crime that's committed at Cedar Junction. Well, the defendant comes in here, and the evidence is in the case is going to be about a particular incident that took place in Cedar Junction. The jury certainly knows that the defendant has been convicted of a crime, even though it's not mentioned during the course of the trial. He would not be an inmate at Cedar Junction without having been convicted of a crime. So I don't think it's fatal to the fairness of, defendant's trial that jurors could possibly suspect that someone has a prior conviction. But I certainly wouldn't plan on mentioning it. I would instruct the witnesses not to mention it. And similar to Judge Dorch Okara's instruction, there could be many reasons why, in that, the DNA database is used in missing persons, servicemen, lots of different reasons in this day and age, and will continue to be as we go forward. But I think otherwise the Commonwealth is prejudiced. And the evidence is what it is, Your Honor. I don't think the timeline that you see is the way it unfolded. I'm just going to ask the clerk to pass that up to the court if you would. Looking at that timeline, it's a 6-year period of time. I think the Commonwealth's entitled to lay that out. Court. Does the defense intend to argue at all or even suggest at all that the Commonwealth was anything other than diligent in their investigation in this case? Ms. Canoni, certainly not regarding the science. Maybe, I'd say no. My God. Certainly not regarding the science. And what's different from this case and Lovato, Judge, if you look at the timeline on this case, the defendant's CODIS hit is not until March 29th of 2006. And I think they got a sample for his blood, the voluntary sample, shortly thereafter. Certainly after 2006? Yes. So the time frame the Commonwealth's talking about, the jurors are going to be wondering, if this were a situation when they first did a DNA profile back in 2003, and got a CODIS hit of the defendant back then that supports the Commonwealth's argument that they were being diligent. But they don't even get a hit on it to the defendant's profile until 2006. He gives the sample shortly thereafter. I can't put my hands on exactly when. So I think what the Commonwealth's arguing, the need for this isn't even being served in this particular case by the introduction of the evidence. Lovato was different when the DNA profile was put into the CODIS database. It immediately bounced back to Martin Lovato. It wasn't, again, another 3-year gap after that initial CODIS hit. And this is compounded by the then introduction by the Commonwealth that the defendant's profile was not there when they first did the CODIS analysis, and then was put in there in 2004. I think it calls for speculation. The court. What occasion is DNA being placed into CODIS? A conviction, so that he was not ever convicted of felony prior to that point. So it's a felony conviction. Is the probative value? Let me ask you this. I'm just really thinking out loud because I haven't had this before. If the probative value for the Commonwealth is to take away any suggestion that law enforcement was not working diligently in this case over the years, what if there is simply a stipulation that neither the defense nor anyone else questions whether or not the Commonwealth was working or law enforcement was working diligently over the years? Okay, so I guess it was the judge's suggestion initially, not Canoni's, but anyway. Mr. Finnegan. Well, again, Your Honor, I appreciate that, but that leaves the issue unsaid. But certainly the jury will be, and one last piece of paper, Your Honor, I did bring just a quote from Commonwealth versus Rosario, not the same issue, but a similar issue, which is in the search warrant context where a police officer is entitled to, should not be put in the false position of seeming to just have happened upon the scene. Well, in this particular case, I anticipate that Trooper Jack Moran will testify that in July of 2006, he obtained a buccal swab from the defendant, and that was based on a grand jury order. So a few months after the CODIS hit, to confirm the CODIS hit, that was actually done right here in this courthouse. But just to have Trooper Moran testify to that will leave the jurors looking at Trooper Moran thinking, well, why did Trooper Moran wait for 4 years? Why didn't he do it earlier? And the answer is, well, he didn't do it earlier because, he hadn't been aware of the CODIS match until, March of that year, March of 2006. The court. Well, what if it went even further to say that not only is there no suggestion that the Commonwealth didn't act diligently in this, but that this particular trooper didn't have any information to go forward as far as the defendant was concerned until a particular date, and as a result of that, the grand jury issued the order. Mr. Finnegan. No, respectfully, Your Honor, I think the Commonwealth, I find that stipulations just never carry the punch of an actual piece of evidence. I know. Well, this is certainly something that I don't have to decide on the spot right here. And I thank you for telling me in advance so I can think about it. Ms. Canoni. And there will be one other thing that I didn't mention to the Commonwealth. There is a witness on the Commonwealth's witness list, the defendant's former roommate, Mr. Maureen, who tells the police and testifies in a non-responsive manner before the grand jury at some length about his suspecting that the defendant was using drugs during a period of time, that the defendant was living there close in time to the incident here. It's speculation on his part. It's certainly prejudicial. Its prejudicial impact far outweighs the probative value. I just don't know if the Commonwealth intends to get into that. And formally, I did not ask Mr. Finnegan this yesterday. I think it's problematic. So if they do intend to get into it, I'd like to address that beforehand. What's he going to talk about? This is a former roommate? Mr. Finnegan. I'll give Attorney Canoni an answer before Monday. I don't expect to get into that. All right. But I do have a couple other issues. Go ahead. Okay, what I didn't realize, Yana, we talked about it yesterday, and then I learned that we could see Your Honor today, so I have not finished my motions in limine. But I anticipate 5, Your Honor, which would be a motion for review. This would be in Quincy Center. Ms. Canoni, I'm not objecting to that, Your Honor. And the next 3 motions in limine, Your Honor, whether it's 1 or 3, you can sort of combine them. It's the same issue. But I anticipate, given the age of this case, that I will have substitute witnesses. That's a problem. For lack of a better term, in 3 instances. Number 1, the medical examiner who did the autopsy has left, Dr. Chirkoff. I would like to call Dr. Evans, who reviewed the autopsy and actually did examine the victim's brain, to testify as to the findings in the autopsy. The medical examiner, where is he now? Dr. Chirkoff, I think, is in Connecticut, working as a pathologist in Connecticut. And who's your witness? Dr. Evans. Dr. Chirkoff did the original autopsy, but I'll propose to use Dr. Evans. And I did tell Mr. Finnegan I'd be filing a motion, an objection under Crawford regarding the substitution. I think the Commonwealth could have an argument against that. I think the Commonwealth could have an argument against that, but I will be filing that. My God. But he would be testifying to looking at the records and interpreting the autopsy records. Correct. And you know the findings in the autopsy report, and together with the photographs taken at the autopsy. And he signs the report, essentially adopting it. That's what Miss Canoni. And he signs the report, essentially adopting it. Why is she helping the other side there? Oh my God. Anyway, Mr. Finnegan. So the next 2, Your Honor, would be related to that, which is there are several lab personnel that have since left the Massachusetts Crime Lab, but their work is reviewed by other DNA analysts. And so in a couple of instances, I would have somebody testify from the Mass Crime Lab that did not do the actual analysis, but has reviewed the work and testified to the results. And these were on particular DNA comparisons from clothing and things of that nature. Correct, Miss Canoni. And that would be the same objection, a Crawford type objection. And then, I don't know. I'm sorry. Go ahead. I don't know the extent that these DNA people independently reviewed the work. I don't know if I guess we won't know until either we've voir dire them or there's some offer of proof on whether they've adopted it. At least with Dr. Evans, he has signed it and adopted it as his own. And Dr. Evans did have a part of it. Where am I? Like Mr. Finnegan said, he cut into the brain and looked at the brain, but we don't know the extent that these substitute witnesses have had. Where was the injury in the victim? The injury, Your Honor, there are wounds to the front and back of the victim's head. This is a photograph, Your Honor, which I guess that's one other motion in limine, which would be some photographs. I don't think they're particularly gory photographs. I think we can probably agree. But there's basically a wound to his nose here in the front, Your Honor, and then 2 wounds to the back of the head. Head wounds, they're all head wounds. Miss Canoni. Blunt force trauma to the head. Mr. Finnegan. Yes, Your Honor. The court. Okay. Miss Canoni. Is the Commonwealth's conclusion. Mr. Finnegan. And along those lines, Your Honor, the last one would be some of the DNA work was done by Cellmark in Maryland, and some was done at Cellmark in Texas. And the person, hold on. Okay, where were we? All right, Mr. Finnegan. And along those lines, Your Honor, the last one would be Some of the DNA work was done by Selmark in Maryland, and some was done at Selmark in Texas. And the person that did the work in Texas is coming up to testify, but Selmark, Maryland, that lab went out of business, the court. I know. I know all about it. Mr. Finnegan, as you know, some years ago, then I would propose to have Dr. Cotton, who was the supervisor down at the lab at the time the work was done, testify as to the work that was done in Selmark, Maryland. She was in Maryland, right? She was, yeah. So those three, Your Honor, the medical examiner, the DNA analyst, and Dr. Cotton. And then the other motion in limine, which I was drafting, it sounds like it's not going to be an issue, or maybe it is, but depending on the way you set up the CODIS question, but limiting the cross-examination with respect to the CODIS system and not getting into the problems that the lab had with respect to the CODIS, Miss Pino being fired, and all of that sort of turmoil at the lab going back a couple of years. I would propose to keep that out as not being relevant, but we might not get to that point, Miss Canoni. If it comes in, I'd like to be heard on that issue because I do think it's relevant. There were problems at the lab and they're relying on it. So, and this was also my proposal for the Commonwealth to keep all of it out. Also keeps all of that part of it out, obviously. So I understand the dynamics. Thank you. Anything else? Are you done? Mr. Finnegan, that's it. Yep, Miss Canoni. The Commonwealth at one point filed a reciprocal discovery motion that was not acted upon. I am aware of my obligations under the case law and the rule. I am in possession of what I think I am responsible to turn over to the Commonwealth. My understanding of the case law is that I'm not obligated to do that without a court order. So maybe it's appropriate that Your Honor order me. Maybe it's appropriate that Your Honor order me to hand over what I say falls under the rules and the case law to Mr. Finnegan. Anything from the government on this? I would ask that, Your Honor, as I understand if the defense is leaning against calling any experts. I haven't received any information on experts, but to the extent I know that there's an investigator working on behalf of the defense, we'd like to have those. I would order what you have other than expert disclosures at this point, the substance of expert disclosures to be turned over. Ms. Canoni, yeah, I have copies for Mr. Finnegan. Thank you. The court. All right, as far as your client for voir dire examination, would he like to be up here, stay seated, or do you want to make that decision on Monday? I'll let Your Honor know Monday. My practice, and I'll speak with Carlos this afternoon at the jail about it. So he wasn't at this hearing. I'll speak with Carlos this afternoon at the jail about it, is that he remains seated here for sidebar. It's his decision, and I'll let the court know on Monday. The court. The deceased in this case, who's Caucasian? Ms. Canoni, yes. The court. What about attending a view, Ms. Canoni? I did speak briefly with Mr. Seino this morning about that, and I understand if he were to attend the view, it would be with strict security around him. And I think where we are at that right now is that might draw too much attention to him. The court. I have had situations, not many, one or two in particular, where a person in custody attended a view and they attended it at a distance, and this in a police or sheriff's car at a distance. Ms. Canoni, did the jurors see him? What? The intention was that they didn't, but would you intend the view to be on Tuesday morning? Mr. Finnegan, yes, Your Honor, I would prefer that it be prior to openings. The court, that's fine, that's fine. Ms. Canoni, I will let your clerk know this afternoon, Your Honor, if there's a desire to attend. Court, well, that's not a decision you have to make until Monday anyways. Thank you. Okay, I appreciate that possibility. I hadn't thought of that. I just assumed the sheriff's department and the court officers. I think we did it. I think it was a Middlesex case out of Hudson. And the person was really about a block away, block and a half away. And I'm not sure it proved satisfactory to anybody. Yeah. But it turned out to be a compromise, and well, whatever. We'll see. All right. I think maybe what I ought to do is just talk to your client now about the fact of making race an issue in the voir dire. May I have 2 minutes? Certainly. I just want to show him the specific question, Judge. So is there? Based on my previous discussions with Mr. Seino, I filed this motion this morning, expecting that this would be something he would like the court to ask. I just now did show him the specific question. He is asking that Your Honor ask it. So if there's okay, I'm not even going to ask him what he wants to do. I just want to advise him. Oh, I'm sorry. Okay. Good morning again. What the fuck? The defendant. Hi. You can stay seated. In most things, there's always an upside down and a downside to most things in this world. Attorneys in cases where there's a racial difference or ethnic difference, and sometimes even a religious difference, but especially a racial difference between the individual who is charged with the offense and the person who is the victim or of the complaining witness, if the person happens to be alive, and in the case, if there's a racial difference, to bring that to the attention of the potential jurors. Because it might be that somebody might have a feeling, because there is that racial difference, that they would tend to bend one way or bend the other way in this case. And so very, very often, attorneys will ask the judge to ask a question of each one of the prospective jurors as to whether it would make any difference that you are of one race and the deceased in the case was of a different race, and would it make any difference in being a fair juror? And so lawyers will often ask that, and jurors think about that, and people will then give a response, and hopefully everybody will give a totally, totally candid, honest response from the heart. That's the upside of it. You get some information that you wouldn't have had otherwise. The downside of it is that you're injecting into the process with the jury that there's a racial difference, and that maybe somebody wasn't thinking race beforehand, and now maybe they are thinking race. Maybe not to the benefit of one side or the other, but at least it's something that's been brought to their attention by the judge. And so it's for that reason, sometimes a lawyer will say, no, Judge, I think we ought to just let it go. So what I wanted to do was just bring it to your attention. Give you till Monday morning to talk with your lawyer about this. And if at that point it's still your view, because I think it's your call, it's your call after getting the advice from your lawyer. So I would just like to know on Monday morning what your position is on this. And if you want me to ask a question that brings out the racial difference, I'll ask it. If you feel more comfortable in not being asked, I wouldn't ask it. The defendant. Thank you, Your Honor. The court. Okay, I'll see y'all on Monday. Ms. Cannoni. I apologize for delaying the court on that. No, you're not delaying it. This is fine. I'll see you people Monday morning. Ms. Cannoni. Thank you, Judge. Mr. Finnegan. Thank you, Your Honor. The court. Thank you. On Monday, you wouldn't prepare anything more than an open statement because you might not even get there. Do you want, well, you could do opening. Wait a minute. You'd like the view before your openings, is that right? Yes, Your Honor. Then prepare for on Monday to go no further than a view opening. So you can tell the jury what you'd like them to look at the view. Thank you. Can I just ask one other question on that, Judge? Sure. The views that I've been on, the prosecutor at the scene drew the jurors' attention to things and did not do, or maybe he did a view opening and then did that. Does Your Honor have certain parameters? Will the prosecutor be pointing things out? Court. I think you have equal station at the view. The jury should know that each one of you want them to come to the view to look around because it should help them understand the case, and they're not there to gather evidence, and that the lawyers, the prosecutor, and the defense lawyer are free to point things out to them at the view. And if I will not be making any statements, I'll advise, Your Honor, because I may want them to be told I don't have to give a view opening. I don't have to say anything. That kind of thing. Fine, okay, tell me in advance. Yes, thank you. And the matter. was adjourned.